school property, the school situation, right before finals week, etc. He wasn't operating at the behest of law enforcement. In fact, the FBI said, don't do this, you're going to mess up our case. But he did it anyway because he felt he needed to protect the school system. So the court held in that case that because of that, he fit under this narrow exception called the special needs exception, where the school was just trying to protect its own computers, and they upheld it, even though they claimed that the student in this case did have a reasonable expectation of privacy. So this is a very interesting case. The special needs exception is hardly ever invoked by the courts. In this case it was, and they have cited it in a few other cases subsequently. So now I will say though, if you look at the bottom, look what the court claimed. The court claimed, besides, the system administrator did not view, delete, or modify any of the actual files in the computer. Okay, how can you search through a computer without viewing, modifying, or deleting any files? I don't know how you could do that. Okay, so obviously the court got the technology a little bit wrong, but in any event, that was their holding. Okay, now this is an interesting case because it deals with interceptions. An individual worked for Valence Media. Valence Media was the company that developed Torrent Spy, and then later he quit. But he was very concerned about what his bosses may say about him to subsequent employers. So what he decided to do is he hacked into their computer system, found out what his boss's email was, and made a copy of all of his boss's emails and had them automatically forwarded to an anonymous Gmail account that he had. So he was basically getting everything that his boss said because he wanted to make sure his boss wasn't saying anything bad about him. Well, eventually he says, gee, they're saying a lot of other interesting things that the Motion Picture Association of America might be interested in, because Torrent Spy obviously is a file sharing software that can share movies, which is a big concern of the MPAA. And so the MPAA said, we will pay you $15,000 for that email that you've collected. So he said, oh, no problem, here you go. So when that happened, his boss sued, saying he violated the hacking statute by intercepting my email, or actually the Federal Wiretap Act. He violated the Federal Wiretap Act by intercepting my email. So do you think that copying and forwarding an email from a hacked account constitutes an interception under the Federal Wiretap Act? How many say yes? How many say no? Okay. Interestingly, the court said no, to everyone's surprise, including virtually everyone in the Department of Justice. Because if this isn't hacking, then we never have to get Title III court orders again. Because it's very easy to go into someone and just forward all their email. Now the court below, what they were trying to do is they said, well, interception, the way I think of interception, it's like capturing the message en route. Like if you intercept mail, you take it out of the mail system. You know, you're intercepting the mail. She says, well, he didn't intercept it because he didn't take anything away. His boss still got his email, and it wasn't even changed. He just made an extra copy of it and forwarded it. So there's no interception. So the court below tried to say, we don't believe this is interception as we interpret that term to be defined. But, you know, it'll be interesting. The case is supposed to be heard on the 7th of October of this year in the Ninth Circuit, and I would be shocked if the Ninth Circuit does not overturn this. Because if this is upheld, then there will be, you know, a lot of police forces that will be very happy because all of a sudden they won't need to get Title IIIs anymore because they can do all sorts of interceptions and not call it interception. Okay. This has become another recent trend in the law, and this deals with the Computer Fraud and Abuse Act and bad purpose. What happened in this case was the Drug Enforcement Agency was conducting a drug investigation, and it turns out that the target was hosting some an informant outing website. In other words, the Drug Enforcement Agency has some informants that no one's supposed to know about. They keep their identity very secretive. All of a sudden, they were finding out that somehow someone was finding out about it, and they were posting it on this website saying, by the way, this guy with his picture, name, etc., is an informant. Watch out for him. And they're like, man, this is just really messing up our investigations. How is this person finding this stuff out? Well, they eventually tracked it back to an individual who had access to NCIC, which is the National Criminal Investigative Center, Crime Investigation Center. And that has all sorts of information on it, which included the identities of these undercover agents, apparently. And so what they said is, well, you should not have been able to pull that data down and provide it to these people who subsequently put it up on this website. Now, what they charged him with was unauthorized access or exceeding authorized access. Now, he did have authority to use the NCIC system. He was a person who was authorized to use that, but they're claiming that, well, the way you used it was not authorized. So the question is, does that fit within the terms of the Computer Fraud and Abuse Act? How many think it does? How many think it does not? Okay. This was also a close call, and the courts have actually split on this. But in this case, they said it does. They said that although he was authorized to access it, he wasn't authorized to access it in this way, so he exceeded his authority. Most courts seem to be going the other way. Most courts are saying, no, this was a hacker statute. And what they meant by going beyond your authorization or without authorization is that you didn't have any permission to do it. Not that you just did it for a purpose that they didn't really like. Because as soon as you start converting it to that, it really starts expanding the statute quite measurably. And so it's unclear how this will go. There was a case that just came down a couple days ago, LVRC Holdings versus Brecka, which I cite in that last bullet, where they're talking about, does disloyalty count? Because some people, when they're about to lose their job, they start sending home all the secret documents on that particular company's machines. And so some companies have sued them under this hacker statute, saying that was unauthorized use of the computer. And a lot of courts are saying, no, no, no. He was your employee. He was allowed to use your computers. You have to prosecute him under some other law. But some courts are now saying disloyal use can actually constitute a hacker offense. So we'll have to see how the courts come down on that. Now, some of you may have heard this case, the social networking case. Drew, she had a 13-year-old daughter. She apparently wanted to somehow help her daughter in some kind of a strange way. So she posed as a 16-year-old boy on MySpace. And then she befriended one of her daughter's friends and set up this whole fake romance. And then she basically told her daughter's friend, basically, it's over, you're not even worth it, blah, 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 and had this really messy breakup, which subsequently resulted in the other girl committing suicide. So this became a very big case, of course. They brought it to the Missouri U.S. Attorney, and he says, I won't prosecute this. This does not fit under any of the federal statutes that I have available to me. Okay, it's unfortunate, it's terrible, but there aren't statutes to cover this. So they brought it to the Los Angeles U.S. Attorney, because MySpace is located in Los Angeles, and they try to get jurisdiction there, and he said, I will bring it. So the question is, do Drew's actions amount to unauthorized access to a protected computer? Now, protected computer under U.S. law is defined as any computer attached to the internet. So when she signed up for MySpace as a 16-year-old boy, but with MySpace's approval and everything else, of course they didn't know she was a woman, an older woman. Does that constitute the hacker violation of unauthorized access to a protected computer? How many think yes? How many think no? Okay, you're all wrong then, because the court actually held that she was. Now that's very strange, because what this basically means, the government's case was MySpace has specific terms of service that you have to sign as part of your contract. And those terms of service say that you won't lie. Okay, we all know that no one lies when they sign up for a MySpace account or does anything else on the internet. Okay, so remember that. But anyway, they eventually said because she lied on that terms of service, she broke that contract, and if she broke the contract, then her access was not authorized because she was not complying with the access. And if her access was not authorized, then she's committed a federal crime. Now, a lot of people didn't like that because they said, wow, a lot of people don't even read those contracts. They just click the end. Yep, whatever, okay. And so they said, boy, you've just made criminals out of a whole lot of people, because a lot of people also lied. They give fake names, Mickey Mouse, whatever else. And so, what does this mean? So interestingly, on the 28th of August, just recently, a judge, she made a motion to dismiss, claiming that the government could not have proved their case, that there were problems with how they charged this, and the judge actually dismissed it. This is not an appeal. The judge, just in retrospect, is saying that even though a jury acquitted her, even though a jury convicted her, as the judge, he's overruling the jury, which is a possibility. You're allowed to do that as long as the law does not support the jury's findings. And he's saying that violation of the terms of service alone cannot transform that into a federal crime. And I think a lot of people are actually more comfortable with that. But it'll be interesting to see where this case continues to go. Okay. This is kind of an interesting case. It just shows how we're going with the law and everything else. Oh, actually, we're getting kind of close on time. So this just basically says if you